Welcome, everybody. Appreciate you joining us today. My name is Chris Hanslick. I'm the chairman of BoyarMiller, and welcome to our webinar to discuss some of the recent legislation, both in the Family First Act as well as the CARES Act. And so we're kind of excited to bring this to you. Hopefully, you've been receiving our information that's been going out through our social media channels, as well as email. There's a dedicated website or page on our website where you can find all of our COVID-19 related materials. And if you received an email from me, there's a link to that. If not, we'll try to get you that. But you can go to www.BoyarMiller.com, and it's right there on the homepage to click to that link. So excited about this. We've heard from many of you in the last, I guess, 24 hours since sending out the invitation, some of your own questions, and we are going to do our best to address all of those. While we're doing that, many of you, I think we're all getting much more familiar with Zoom, and probably wish we had bought in stock about a month ago. But regardless of that, there is a chat feature, and we'll try to monitor questions there, but there's also the Q&A button at the bottom of your screen when you kind of scroll down there and get the toolbar. We'll monitor that as well. If questions come up while we're in the webinar, we'll try to address them. You know, information, as you all know and are experiencing, is coming at us all very fast. New things, and we're all doing our best to digest it as fast as we can and try to make decisions that will help keep our businesses alive and viable, hopefully keep as many people as employed as possible through this time. But it's certainly some uncertain time, and we're doing our best to hopefully provide or be a resource of information to help you make those decisions in an informed way. So one thing I do want you to know is we're not gonna be able to answer everything in the hour we have. So our plan is to do our best during this webinar, but after that, take not only what we've talked about in this webinar, but any questions you submit during that time, and create a FAQ, a frequently asked questions page, to then disseminate out, have it on our website again, and we'll try to push that out to all of you that have attended this webinar, so you have it directly, but then know you can go back to our website in another day or so and have everything in one place. So hopefully that will be helpful to you. And of course, you know, if something else comes up, you can always feel free to reach out to us directly. With that, I want to get us started. I'm going to start by having our panelists introduce themselves to you, and then we'll get going with some of the Q&A. So Steve, you want to lead us off?
Yeah, sure. So hi, everyone. Welcome to our first webinar. Pretty excited to be part of this. Again, my name is Steve Keston, and I am a shareholder here at BoyarMiller. I'm also the head of our business group. The business group is where we house all of our corporate and real estate practices, and under the realm of finance, private securities, and general corporate. But we focus our practice on the small and middle market businesses. So obviously you can see why we're so interested in the CARES Act, because it's affecting most all of our clients. I've been practicing for 30 years now, 20 years with BoyarMiller, and all that time in the corporate securities and finance M&A practice. So I think that gives you a pretty good idea who I am.
Okay, I'll jump in next. My name is Taylor Gaber, and I've been an associate here at BoyarMiller for a little over a year. I focus on corporate and real estate transactions, and with Steve, we have been following this CARES Act as closely as we possibly can over the last couple weeks, so hopefully we can answer a lot of your questions.
And I'll jump in. Good morning. Steve said, welcome to our webinar. I will say welcome to my virtual dining room. So my name is Matt Veach. I've been with BoyarMiller for about 15 years. Been practicing lawyer for a little over 20 years. My practice is in the area of employment law. I do commercial litigation along with Chris, but also do employment litigation, employment counseling, human resources support. And so I have been on the phone a lot in the last 10 days to 2 weeks. And I think there's Obviously, two new laws we're going to be talking about on this call, and there is daily, seems like daily, updates and guidance from the Department of Labor. So we'll try to hit some of those important things, and Chris is fielding questions, so as those come in, he'll fire them our way. But welcome, and thank you all for attending.
Great. And so I think one of the things we're all learning to do is adapt in this new Zoom world. And I know what I'm seeing is, and it may be happening to me, as someone's speaking, there's a little bit of a delay. We apologize for that, but despite having great internet access at home, I think it's unavoidable. It's been my experience over the last several days. So hang with us if it looks a little slow, but hopefully we still get the content delivered to you. So to start things off, Steve, I think what would be a good thing to share with everyone is, what's the most important thing that you think the people on this webinar with us need to know today about the CARES Act?
Yeah, so I have a pretty good feeling that most people on this webinar are interested in knowing whether or not they're eligible for this new loan program that's been enacted. And then if they're eligible, what are they eligible for? So I'd like to focus on those. But before I do that, I thought I would tell everyone a little bit about what the CARES Act has done generally for small businesses, because it's done some pretty amazing things. So the CARES Act, what it did is it enacted a new program called the Paycheck Protection Program. And what that does is it amends the already existing SBA loan program under 7A of the SBA Act. And what that is just the customary place where small businesses would go if they were applying for a SBA-backed guaranteed loan. So the Paycheck Protection Program has done made some amazing amendments to that program. It has increased the pool of eligible borrowers for those kinds of loans. It's increased the amount that each borrower is eligible for. It's changed the terms of those loans in some amazing ways that are favorable to small businesses. And in a way that I believe is unprecedented, it has made a large portion of the loans that are going to be received forgivable, and will provide for some significant payment deferrals. So we're going to focus a lot on those items, but what I wanted to start with was, okay, who is eligible under the program? Because I think that's probably the first place where people are going to start. Am I eligible? And then what am I eligible for? So who's eligible? So under the eligibility of the CARE Act, every small business is defined under the SBA Act. So this is under the previous law of 7A, any small business could acquire a loan. And how did you determine whether or not you were a small business? Well, you would go to the SBA's website. You would look at the sheet that they have that's broken down by NAIC industry codes, and find your industry, and then see if you fall within the number of employees or the revenue amount to qualify you as a small business. If you did, then you are eligible to get a loan under the SBA. Now, what the Paycheck Protection Program has done has increased eligibility for employers who have not less than 500 employees. That means that whether or not you were eligible under the old program, under the revenue amounts, if you have 500 employees or less, you would be eligible now. It also provides for the ability to get a loan if you have more than 500 employees, if the size standard under the SBA requirements, under your NAIC code, allowed for more than 500 employees. So for example, many of the manufacturing industry codes provide for a small business being a business that has more than 500 employees, some as high as 1,500 employees. So if you fall within that NAIC code and you are eligible for an SBA loan currently at a size greater than 500 employees, then you would be eligible for one now. It also provides that you're eligible for a loan if you are a sole proprietor or if you're a self-employed person. So long as you pay payroll costs and you are a sole proprietor or self-employed, then you can qualify for a loan as well. Other exceptions to the 500 employee rule are if you have an NAIC code that is under 772, which is accommodations and food service programs or industries, and you have more than 500 employees, so long as you have not more than 500 employees at a physical location, then you are also eligible for a loan, even though you have an aggregate of more than 500 employees. So that's the eligibility requirements.
Great.
In essence, if you have more than 500, or sorry, if you have less than 500 employees and you pay payroll costs, then you'd be eligible for one of these loans.
Great, Steve. Thank you. So Taylor, kind of same question to you. What do you think people need to know today, or what's most important today for someone to know about the CARES Act?
So as Steve mentioned, the CARES Act has set forth some really favorable terms for borrowers on these loans. Just going to run through them really quickly. Interest rates capped at 4%. But just recently, as early this week, the Department of Treasury has said that the interest rate's actually only going to be 0.5%. So that's very, very low. There's going to be no personal guarantee required, no collateral. There's no prepayment penalties, which used to be as high as 5% before the CARES Act. So that's a pretty significant change. The maximum maturity in the Act is set for 10 years, but recently the Department of Treasury has said these loans are going to be for a maturity of 2 years. And there's going to be no fees charged by any government or lenders related to these loans. So then, Chris, just to follow up on, I think the biggest question that Steve and I are getting is related to this loan deferment and loan forgiveness program. The loan deferment is pretty straightforward. The Act says that all loans are deferred for 6 months, so you don't have to pay principal or interest for 6 months. And the Department of Treasury has confirmed that that is true. That is 6 months. Pretty straightforward. As for the loan forgiveness section, that gets a little more complicated, but it's a very important part of the CARES Act. Portions of your PPP loans can be forgiven. This does not include there's no forgiveness rather for economic injury disaster loans. It's only these PPP loans. And that amount that can be forgiven is the sum of all the costs that an employer spends during that first 8-week period after you get your loan. But it's the sum of all payroll costs, interest on mortgage, rent, and utilities. It's important to note here that the mortgage, the lease where the rent is charged to, and the utilities must have been in service before February 15th of this year. So if you just got a new lease or new utility service, those costs will not be forgiven. And then payroll costs, it's a pretty extensive definition. It includes salaries, wages, health insurance premiums, retirement benefits, PTO for both employees and independent contractors. And these payroll costs are capped though at $100,000 per employee or independent contractor. This, it's important to note here that this is a point of confusion for all of us. The language is a bit murky and we're waiting for guidance on whether that $100,000 cap is inclusive of only wages and salaries, or if it's also inclusive of amounts paid for wages, salaries, health benefits, retirement benefits, PTO. So hopefully we get some guidance on that as early as tomorrow. Go ahead.
No, go ahead and finish. And then I was going to suggest that we go back to what amounts people qualify for that will relate to what you're forgiven. But go ahead and finish it.
Okay, perfect. And the big point too here we want to mention about loan forgiveness is it ties into one of the benefits of this act, and the CARES Act is designed to encourage employers to keep people employed and to keep people being paid. So because of that, there are certain what I'm calling forgiveness reduction penalties. They're not called penalties in the Act, but it's easier to think about them that way. And there are certain formulas set forth for reducing the amount that you can have forgiven if you have laid people off or if you have reduced your salaries or wages of certain employees. Won't go into all of that now. It's a bit cumbersome. Last thing I wanted to mention before we move on is that the Department of Treasury this week has released some guidance showing the importance again of payroll costs and keeping people employed and people paid. For loan forgiveness amounts, you need to remember the 75-25% ratio. What they've said is that for loan forgiveness amounts, 75% need to be for payroll costs, and 25% can only be for those other rent, mortgage, interest payments, and utilities. So that's going to be very important when you're looking for how much you're asking for and for how much you're asking for to be forgiven.
All right, great. Thanks, Taylor. And to the for those of you listening in, the point that Taylor was making, where she said that, it's a little too cumbersome to cover now. That information will be available on our website and already is in some of the articles we've written, but we'll be sure to provide that detail. Didn't want to burn up too much of our time on the webinar with that. So, Matt, let's talk a little bit about Families First Coronavirus Response Act. I'm just going to call it the Family First Act, if that's okay. So, what you've been dealing with for the last week or two with clients, as you sit here today, what do you think the most important things someone should know is as it relates to the Families First Act?
Sure. Well, let's start with what it is in kind of a high level, Chris. So the Families First Coronavirus Relief Act, basically for purposes of your employees, it created two new laws. The first being an expansion of the existing FMLA, Family Medical Leave Act, simply an expansion, did not change, alter, modify in any way the old act. The old act still exists, it's still the law. This is additional law. And I'll talk about what's additional in this law here in a second. But the second new law in the employment context in this area is the Emergency Paid Sick Leave Act. So cover that one first. So the Emergency Paid Sick Leave Act basically is the act that gives employees 80 hours of paid sick leave. It's triggered by the employee having falling within being eligible under one of 6 categories. And what the law says is that if the employee is unable to work or telework, and I emphasize telework because I think for our audience that's going to be an important area, because that's the area I see really developing right now. But it says if the employee is unable to work or telework because they are subject to a quarantine or isolation order related to COVID-19, they've been advised to self-quarantine due to concerns related to COVID-19, they're experiencing symptoms of COVID-19 and seeking a diagnosis, they're caring for an individual who falls within any one of those 3 I just mentioned, or they're caring for a son or daughter whose school is closed. And then they've also added a 6th category that I don't know yet what it's going to cover, but it basically is it says if the employee is experiencing any other substantially similar condition. So basically this is if somebody is impacted, if an employee is impacted by COVID-19, they are entitled to 80 hours of paid leave. There's a number of issues that come up around there, but that's kind of the premise of it. The Expansion Act. The Expansion Act did 3 big important things relative to the FMLA. First, it changed the definition of an employer, but only for the Expansion Act. The old definition still applies to the old act, which the old definition being you're an FMLA employer if you have 50 or more employees. The new act did away with that 50 employee floor and instead said if you're an employer of fewer than 500 employees, you're subject to the Expansion Act. And what the Expansion Act is that an eligible employee, which they also changed the definition of that, or it's a new definition from what's under the existing FMLA. But what it does is the Expansion Act gives an employee a right to 12 weeks of FMLA leave, basically if the employee is unable to work or telework because of a school closure, because of COVID-19 reasons. Now, interestingly, they not only, like I said, they changed the definition of employer, so it covers anybody that's 499 and down. They also said an employee is anyone that's worked for the employer for 30 days. Under the existing FMLA, you had to work for 1,250 hours. You had to have been an employee for 1,250 hours. So it's definitely broadened. So if the employee meets that definition and the employer meets that definition, the first 2 weeks of the 12 weeks is unpaid. The final 10 weeks are basically, generally speaking, paid at 2/3 of the employee's regular pay. So it's, you're not paying at the full load, you're paying at a reduced load. Those are the two new laws. What's happened since then is the DOL has come out with guidance, and I think there's a number of important areas of guidance that I'm sure we'll get into on this call. But the other thing I would say that I know folks are wondering out on this webinar are, we all know that under these new leave laws, there is the exemption for small businesses, which are small businesses under, is defined as an employer under 50. And it basically is if complying with the law would basically, I don't have the exact words in front of me, but it affected going on viability of the business, you're exempt from it. Well, nobody really knows what that means. So the DOL, Department of Labor is to come out with regulations. And as of a few days ago, the DOL's guidance on this said, we don't have regulations yet, but they're forthcoming. So to the extent anybody's wondering about that, we're still monitoring and we're waiting for guidance on the small business exemption.
Okay, yeah, good. That's good to know, Matt. Thank you. So Steve, I know a lot of people are asking, what seems to be a pretty simple, straightforward question. Are payments to independent contractors included as payroll cost?
Yeah, I think the answer to that is that if you are paying an independent contractor and to them it is compensation, it will be covered under the definition of payroll costs. So that will be included in determining the amount of the loan that you'll be able to obtain. And then it'll also be included in the uses of those proceeds. So to step back for a minute, I'd like to talk a little bit about the amount that you qualify for. Taylor mentioned a lot about forbearance and forgiveness, but let's talk a little bit about how much you can get. Because once you're determined whether you're eligible, which we've already talked about, then the next logical question is how much can I get from this program? So the program increased the amount that small businesses are eligible for to an amount equal to 2.5 times your payroll costs, but you can't go over $10 million. Okay, so the crux of the question then becomes what constitutes payroll costs? Taylor went through a little bit of the comprehensive list, but the Paycheck Protection Program has been very specific about what constitutes payroll costs. So let me go ahead and list those out real quick. It includes salary, wages, and commissions. It includes cash tips or equivalents. It includes payments for vacation, parental, family, medical, or sick leave. It includes payments for dismissals or separations. It includes payments for health benefits. It includes payments for retirement benefits. It includes payments of state and local taxes required to be withheld from an employee's paycheck. And then it also includes, the question that was just posed, includes payments to independent contractors or self-employed persons that constitute compensation to them not to exceed that $100,000 limit that Taylor mentioned, prorated. But it also excludes some very specific items too, and I think this is where employers are going to get tripped up a little bit, because you have to exclude from your calculation compensation costs in excess of $100,000 that we've talked about. You're not allowed to include your federal withholding tax. So the employer portion and the employee portion of federal withholding tax is not supposed to be included. And I think that's going to trip some people up. And then you can't include compensation to employees whose principal residence is outside the United States. And then you cannot include wages paid for which credits are available under sections 7001 of the Families First Act and 7003 of the Family First Act. and those relate to sick leave and family leave. So generally speaking, 2.5 times your payroll costs, and that is an average. So it's your monthly average payroll costs, and you determine that monthly average by examining the 1-year period prior to the date that the loan is made. And if you're a seasonal business, you can look at a different period. And then if your business was not in existence for that full year period, then you have another period that you can look to determine what your monthly average payroll cost is that you can multiply by 2.5.
Great. So Steve, any guidance on what's included in the definition of utilities in calculating the payroll cost?
Yeah, so it's pretty much anything that you would think of as utilities: electricity, water, internet. It even says something about transportation, which I'm not sure exactly what that means, so we're waiting for guidance on that. But I'm pretty confident that it's going to be your typical definition of what constitutes utilities.
Maybe we're waiting on the guidance, but if internet's included, what about like cloud services? So many people have their IT services in the cloud. Any indication whether that would fall under utilities at this point?
Well, without clear guidance, I don't know the answer to that, but my guess is that if it is a payment to a vendor that's not compensation to an individual, I would think that it would be excluded, right, as part of payroll costs. But if it's a true utility, meaning what I just mentioned, water, electricity, internet, I think it'll be included, but I'm not sure if it's going to expand to a service provider that's providing your cloud service and is providing your support services.
Okay. And have we covered, I know you were talking about kind of what you're eligible for. Did we cover the look back period of how you determine your average monthly payroll cost to then do the 2.5 multiplier?
Yeah, we did. So you look back 1 year from the date that the loan is made, which is going to be a little bit tricky. So I bet there potentially will be a change to that, because it'll be very difficult to know exactly what your payroll costs are all the way through to the date that the loan is made. I suspect, and I'm just guessing here, that it'll be likely that you'll go to the end of the month prior to the date that the loan is made, but I'm not sure yet.
Okay.
But it is the 1 year period prior to the date being made, probably as close as you can get the information to that point.
Great. Taylor, there's been a lot of conversation and discussion about the SBA's affiliation rules and how they apply to the Paycheck Protection Program. Can you shed a little more light on that for us?
Sure. So the CARES Act talks about affiliation rules briefly. It sets forth 3 types of businesses where the affiliation rules are no longer going to apply. So said in another way, affiliation rules apply except for certain businesses with an NAIC code that Steve mentioned earlier, related to accommodations and food services. So they're helping out hotels and restaurants that are probably a little bit just over impacted by this. Affiliation rules also won't apply to certain franchisors and franchisees that are assigned a franchise identifier code by the SBA. And then if certain businesses have received financial assistance from a small business investment company, those also won't have affiliation rules. But if your company does not fit into those 3 exceptions, as we're interpreting this, the CARES Act, you still have to go through the normal analysis for affiliation rules.
Okay. So Matt, you mentioned earlier something about the telework and how that's been emphasized and at least by the Department of Labor in interpreting the Families First Act. Anything else you can kind of share about how you see that playing out and how that's going to affect employers in determining whether these various leaves will apply to their employees?
Sure. I think the issues right now are this. So under the statute that Congress passed, it has this concept of being unable to work or telework, as I mentioned earlier, but they don't go into any explanation of what that means, unable to telework, or for that matter, unable to work. However, the statute then gives authority to the Department of Labor to issue regulations and guidance on enforcement. Now, obviously, the Department of Labor is an administrative agency. The guidance matters. As an employer, we can rely on it, but it's not a decision of the court. So some of this may in the future be decided differently by a court than what the Department of Labor is necessarily saying. With that background, the most recent guidance says a couple of interesting things about telework. They define telework, this is what they say, as close a definition as they give. They say, you may telework, you being an employee, may telework when your employer permits or allows you to perform work while you're at home or at a location other than your normal workplace. So it kind of means what we all might think it means, right? So in practice, I'm encouraging employers to allow their people, and have been before all the isolation orders, work from home. We have stay-at-home orders. There's obviously essential businesses that are accepted from that. But if your employee can work from home and you allow and permit them to work from home, I think there's a good argument that they are not, quote unquote, unable to work, and therefore, quote unquote, not entitled to the paid leave under the Act. Now, if I can tell you one other thing on this point that the DOL guidance says, it says this: if you, being the employee, if you and your employer agree that you will work your normal number of hours, but outside of your normally scheduled hours, for instance, early in the morning or late in the night, then you are able to work and leave is not necessary unless a COVID-19 qualifying reason prevents you from working that schedule. So the DOL's guidance here is employers, employees work together, be reasonable, find accommodations to allow people to not only remain employed, but to remain working. So I think they at multiple times in this new guidance they use the word encourage. We encourage the employer and employee to work together. And so what this tells me is that what we as employers need to be doing is having a conversation with our employees who need to be home because of an isolation order or need to be home to care for their children. We need to be working with them, coming up with solutions that allow them to continue working so that they can be paid and we can try to move forward.
Okay, that's good. Good. So back to Steve or Taylor. If someone out there has applied or plans to apply for an economic injury disaster loan, does that affect their eligibility for the Paycheck Protection Program or the loans through that program at all? You know, if so, how, and if not, how do those two work together?
Yeah, so I don't think it will impact them significantly, only to the extent that they get a loan under the EIDL program. It will reduce the amount that they can get under the Paycheck Protection Program. So for example, if under the EIDL, which is the Economic Injury Disaster Loan Program, that's under Rule 7B2 of the SBA Act, where the Paycheck Protection Program is under 7A. That program allowed for loans to be made after a injury resulting from a disaster. So if an area was determined to be a disaster area, then you can quickly get these loans up to a certain amount. That program has now been amended slightly by the CARES Act as well to provide that the COVID-19 crisis is deemed to be a disaster under that act, so people can apply for loans there. But if you get a loan there for some number, and it will be added to whatever your eligibility is, or reduce the amount that you'd be eligible for under the Paycheck Protection Program.
Okay. So Taylor, will the laying off of employees kind of obviously some people have been doing that. We've seen unemployment numbers go up drastically. How does that play into the loan application process? And, what advice do you have for business owners that either have laid off employees recently or are planning to, as it relates to calculation of payroll costs, whether those people should be rehired or, kind of what under the CARES Act can you offer for kind of guidance on that?
Sure. So the big thing to remember when making the decisions about laying people off or reducing your salary is that is going to affect the amount of your loan forgiveness. It's not going to affect the amount that you can ask for, the maximum amount of your loan, because that's just based on payroll taxes from last year, or payroll costs rather from last year, but it will affect the amount that gets forgiven. So if a big proponent of you doing this loan is because you want it to get forgiven, you'll have to take that into account. If you've already laid people off or reduced salaries and don't want to face a reduction of your loan forgiveness amount, we're recommending that you rehire them and continue to pay normally, either right before you take the loan out or right after you take the loan out, so that you won't be affected by that reduction penalty, as I'm calling it. Important to remember, though, that the loan forgiveness is only for that first 8-week period. So after your 8-week period is over, if things are still, hopefully things will be better by then, but if not, you may need to reevaluate decisions then too. So do you have anything to add there?
Oh, go ahead. I'm sorry.
Yeah. So what I would say is, it's pretty interesting because, you get that 8 weeks of forgiveness period, but you're only getting 2.5 times your payroll costs, but what you're able to forgive is all of the other items in addition to payroll costs, your utilities, the interest on mortgage, and then your rent. So if you combine all those amounts, you're going to get to a pretty high number, pretty close to the total amount of the loan that you were able to obtain. So there's going to be potentially a very small amount that you'll ultimately have to pay back after the forgiveness is applied.
So with regard to that forgiveness piece, I know at the end of the 8 weeks, you look at the head count and whether there were changes. And so the question is it just a generic head count? So as an example, if an employer loses an employee or two, but rehires so that the head count's the same, it's not a exact same person calculation, or is it not? I guess is the question.
I'll jump in here, Steve. I have not seen anything that has said that it has to be the same exact employees. As I've been interpreting it, they're just looking at the number. So it could be the same people, it could be completely different people. Can't say 100% because it doesn't say that specifically, but it just talks about the number of employees.
And it's the average number during the covered period, which is that 8-week period with regard to the forgiveness concept. And then you compare that with what your average was for a previous period. And there's 2 different periods that you can use, and whichever one is more favorable to you. So you would examine the average number of people that you had during the covered period by the period of February 15th to June 30th, 2019, or January 1 to February 29 of 2020. So it's either the 2-month period beginning of this year or the period between February 15th through June 30 of 2019. And whichever one is better for you, right, Taylor?
Mm-hmm.
Then that's the amount that the reduction will apply to your forgiveness amount.
And kind of last point on that, is it headcount or full-time equivalent calculation?
Oh boy.
It's full-time equivalent employees.
Okay. So,
and so Chris, just let me jump in, because that's different than the calculation for the 500 employee number. For the 500 employee number, it's both full-time and part-time employees.
That's good to know. Thank you for the clarification. So 500 or less employees, it's full and part-time, and calculating payroll costs and head counts for forgiveness purposes under the Paycheck Protection Program, it's full-time equivalent. So Matt, I know you've been in lots of conversations about layoff versus furlough. in the last couple of weeks. Can you just kind of share a little bit of, what those are and what are the differences and the pros and cons maybe of considering one versus the other?
Sure. Let me begin by saying it's very nuanced. But here is my general statement on that, Chris. Well, the other concept that we're hearing a lot too is reduced pay, reduced hours. Okay, so that plays into this discussion as well. So a layoff, or what we used to call and still call reduction in force, is basically a termination of employment. There's no expectation the employee will return, and the employee at that moment is entitled to post-employment benefits like unemployment if they are eligible and qualify, COBRA if they're eligible and qualify, and so that's a layoff. A furlough, in the general sense of things, for private employers, is akin to a layoff in that the employee is no longer going to receive pay. The employee is no longer going to work any hours. However, the employee would, in a furlough, remain as an employee for benefits purposes. And so the important thing in considering a furlough as opposed to a layoff would be you must contact your benefits provider, primarily your health insurance benefit provider, and confirm that you can in fact do that. And the reason that's important, or the reason you have to do that, is the definition of an eligible employee under employer provided health care is basically a full-time employee, which is generally defined as 30 or more hours to be compliant with Affordable Care Act. And so once you furlough someone, that person is no longer working 30 or more hours. So they are potentially no longer qualified, no longer eligible, and should be on COBRA or the state act equivalent. So the risk you run as an employer in furloughing is you think you have an employee who's covered by your employer provided health care, but they in fact aren't. And then down the road, some sort of health event happens. That employee has significant health insurance costs that everyone believes are going to be covered by insurance. And the insurance company looks at it and says, wait just a second, this person wasn't eligible. They didn't meet the definition of being a full-time employee, no coverage. Now we have a mess on our hands. So before you ever think about a furlough, and everyone who's called me about it, I've said the first thing you got to do is get on the phone with your broker and confirm that you can do that under your plan. I think most plans are absolutely relaxing that requirement right now because they want to try to keep people employed, even if these people are not realizing any wages.
Gotcha. Okay, that's great.
So real quick, Chris, one more thing that I mentioned,
Sure.
because it ties into furloughs and layoffs, and that's reduced hours, reduced pay. Big picture. You can pretty well do that safely with your hourly non-exempt employees. You can reduce hours, you can reduce pay of those folks, keep it above minimum wage. If they happen to work more than 40 hours a week, pay them overtime. With your salaried employees, it's a bit trickier because you have a predetermined salary that person's entitled to no matter how much time they work during a week. So I would be very careful around reducing salaries of exempt employees.
Okay. Is it an issue where you need to treat all similarly situated the same?
Yeah. So always, apply your decisions in these regards, whether it be layoff, furlough, reduced pay, in a non-discriminatory manner. Make sure it can't be come back and questioned in the future. The other advice I give is do not use the furlough layoff concept at this point to get rid of your low performers. Don't be very objective or in how you are choosing who is going to be selected for layoff or furlough if you go that route.
Okay. Thanks, Matt. That's great. Kind of back to Taylor and Steve. This goes to, you know, at least I don't know who all's on this call, but I'm guessing given, you know, some of the people we represent, which include real estate developers, there may be some questions out there, you know, especially on maybe the multifamily side of the equation, but also in office and retail. How does the Paycheck Protection Program and through the SBA work for these special purpose entities that, you know, different projects under different entities, but they're all maybe managed by the same property management company? You know, how does that work with the affiliation rules and the eligibility for loans? Can it be done by property specific? Each one apply for their own loan, or is it done in the aggregate, or does it depend? And if so, on what?
So Taylor, you've done a lot of work on the affiliation rule. Do you want to start?
Sure. So I think your first step is to look at the CARES Act and see if it applies in any of those 3 exceptions to the affiliation rules. Based on the facts we have here, it doesn't sound like that will apply. So you would then go defer back to regular SBA affiliation rules, which really center around control of the special purpose entities. They'll look at ownership to determine control, and they'll also look at who's on the board, who's running the day-to-day operations, and they'll look at all that in a totality of the circumstances to determine if all of these entities are affiliated. In the application process, there is a place for you to mark if they're affiliates or not. So you would have to disclose that early on in the process. And then they would do the loan based on the grouping of affiliates.
Right. So the affiliation goes to whether or not you're eligible as a whole. So when you combine all of those companies and if you have more than 500 employees, then you will likely be outside of eligibility. If you are eligible, I think it's a business decision on how you apply, right? So if you have clear distinction on payroll costs per entity, then you may be better off applying on a per entity basis. But there's a possibility that you could aggregate and go up to the entity that is the controlling entity and apply once for everybody.
Okay. And you both have spoken about the forgiveness aspect of the Paycheck Protection Program. I didn't hear you say anything about economic injury disaster loans and forgiveness. So is it correct to assume there's not a forgiveness element to those loans?
That's correct.
There is not. There is one unique feature of the EIDL, which is that if you apply for it, you can request an immediate $10,000 grant. And that grant is required to be provided by your local bank within 3 days after you apply for it. And even if you ultimately get rejected for the EIDL, you do not have to pay back that $10,000. Where it will be a bogey for you is that if you do ultimately get a loan under the Paycheck Protection Program, that $10,000 will reduce the amount of the forgiveness availability.
Okay. And again, going back to how we calculate, or someone would calculate payroll costs, how do you treat employee bonuses in that calculation?
I would say that you are eligible to include bonuses paid during the 1 year period to determine what your average is, so long as you don't go over that $100,000 cap.
Okay. And then another, I think, question that's come up is this full-time equivalent. You know, how do you go about calculating that, and get, you know, any guidance on that you can share with how someone goes about calculating their FTE?
That might be a question for Matt. Because there's no guidance yet as to what a full-time equivalent, the definition under the SBA Act. At least we haven't delved into that. But a full-time equivalent, just generally, Matt, what are your thoughts?
I don't know how it's going to be defined. I can't provide any guidance there.
Okay. Well, it's something we can look into maybe a little further and include it in our FAQs later. Matt, You mentioned how in the FMLA leave, the first 2 weeks are unpaid. Are there other avenues an employee might be able to trigger to get those 2 weeks paid? One thing that comes to mind is the Mercy Paid Sick Leave Act. Is that something that the employee would be eligible for in that circumstance?
Yeah, my reading of them, Chris, is that the two acts are intended to work together, and that first 2 weeks is kind of emergency automatic pay for a broader class of reasons. The extended additional 10 weeks of paid leave under the Expansion Act of the FMLA is solely limited to the one singular reason. Let me share one other thing that's been a question that's come up a few times and may be of interest to our listeners, and that is the concept of intermittent leave. Intermittent leave is something that's recognized under the FMLA historically, and that is you don't have to take all 12 weeks at one time. You can take it in intermittent periods of time. The Expansion Act was silent. It was unclear whether intermittent leave would apply to the two new leave acts, and the DOL guidance absolutely makes clear that it does in most circumstances. You won't be able, you cannot take intermittent leave if you're taking the extended or the emergency paid sick leave or the FMLA Expansion Act leave if you have one of those COVID-19 illnesses, is what I'm calling them, because obviously it would not make sense to have intermittent leave where you're working some, not working some when you are contagious. However, with these, if you're taking this emergency leave or Expansion Act leave to care for a child because that child is in school, intermittent leave is available. And this gets back to the point I was making earlier about the encouraging employers and employees to work together. One of the examples they give, the DOL gives, is they say, for example, if you agree on a 90-minute increment, you could telework from 1 to 2:30, then take leave from 2:30 to 4, and then return to teleworking. So almost building in this aspect of care for your children, but also try to continue to telework to the extent possible. And then they follow up, the department follows that up, Chris, with this. The department encourages employers and employees to collaborate to achieve flexibility and meet mutual needs. And the department is supportive of such voluntary arrangements that combine telework and intermittent leave. So again, I think employers should be working with their counsel as they have these leave issues come up, which they're only going to increase as these number of cases and the number of positive tests come back. Let's work together, be creative, document how we're going to make this work, where people are doing telework, staying productive, but at the same time getting their rights to paid leave.
Okay. Steve and Taylor, there are several probably sole proprietors out there, maybe that provide some type of consulting services. How do the loans provided under the CARES Act apply to a sole proprietor?
So generally speaking, under the eligibility requirements, it would apply in essence the same way it would for an entity. You can examine, the rules are specific in that sole proprietorships are eligible to get loans. So you would examine payroll costs in the same manner that you would otherwise. So if you pay yourself, and you have people that you pay, you would examine the 1-year period prior to the date that you get a loan if you apply for a loan, in the same manner that an entity that has 500 employees would.
Also, anything in the CARES Act about the ownership of the applicant? And so, as an example, does all the ownership of an applicant have to be U.S. owners, or if they're foreign owners, does that somehow affect your eligibility, or if it's majority owned by foreign or outside the United States? Any guidance on that?
Well, haven't really seen. Have you seen anything, Taylor, other than that you cannot pay or include wages for which the employee's principal residence is outside the United States.
I've seen that, and then I just submit the actual application that the SBA's put out. You have to, as a borrower, represent that you're only purchasing American-made equipment and products. So I don't, to the extent that your foreign entity may not do that.
I'm also noticing that there is, and by the way, we are looking at a form that's been flying around the internet. We're not sure if it's the official SBA form yet, but it does reference Paycheck Protection Program. It's SBA form 2483, and it appears to have been released March 2020. So it looks pretty legit. It's a very simple form, but there is boxes to check that I am a U.S. citizen or I have a lawful permanent resident status. So you will be asked to certify certain elements with regard to your citizenship.
Okay. We're kind of getting near the end of the time. One thing that I did want to address, and that is obviously our practice is largely for-profit business. That's what we've been talking about. But how does the CARES Act apply to nonprofits?
It applies again in the same manner that it would for any other entity, sole proprietorship. The act is very specific that nonprofit organizations are eligible to receive loans. So you would do the same analysis that I previously described, where you would determine what your payroll costs are to the people that are engaged or employed by the nonprofit to determine the amount that you're eligible for. And then what you can use those proceeds for is the same as we previously described for payroll costs, for utilities, for interest on mortgages, etc.
Okay.
And rent.
Very good. Well, Matt, anything that, as we kind of wrap this up, that you could say employers kind of should or shouldn't do as it relates to their employees and the Family First Act, as dealing with kind of best practices right now, and what your maybe top two things to tell an employer they should be doing or be looking or considering doing as it relates to their workforce?
So yeah, it would be my two takeaways of currently today. One is, as you have employees that are making the request for leave under the acts, work with them to see if there's a work remote telework solution so that they can stay productive. If you're one of those employers faced with the situation of literally having no work for your people, the good news is the guidance certainly clarified that if the work site is closed, then the employee is not, and the person loses their job because the work site is closed, the employee is not entitled to the benefits under either of the acts. So that's some good guidance that we did receive.
Very good. Thank you. So kind of, again, Stephen Taylor, maybe in the last minute or two we have here, what's the one kind of takeaway you would give to those attending that they should be doing now as it relates to Paycheck Protection Program?
Sure, Taylor, I'll go first. So what I would recommend is that you reach out to your banker, because these loans are going to be administered through your banks. So the best relationship that you have, get in touch with them, start the process, start accumulating all your information relative to your payroll costs so that you can come up with your numbers, determine what your average is over the previous year, and then you can continue to add to that information as you get closer to the loan being made. The application is very simple. So at least for now, we're not sure exactly what additional information is going to be required. You might get more information, more specifics from your banker, because they're going to have some responsibility to due diligence, to verify, what your numbers are. And the layperson is not going to know exactly what constitute payroll costs, so they may be throwing in things that they're not otherwise eligible to do. And then it's going to fall on the banks to to kind of tell you what you can and cannot do, or give us a call and we can help you out as well. And we're about to see a unprecedented intentional run on the banks, right? Because there is, think about it. So every small business in the United States, in essence, is eligible for these loans. So I can't even gather to estimate how many applications there's going to be. So the sooner you get to your banker, get the process started, the better for you. And there's even some discussion about the possibility that $349 billion is not going to be enough.
Yeah. Taylor, anything to add?
The only thing I'll add is that I believe applications can get started tomorrow. The Department of Treasury has said April 3rd, and that we are also expecting and hoping to get some guidance that can help with some of these questions. So check back with us, maybe not Saturday, give us a day or two to read it, but check back with us early next week if we do get any guidance to clarify some of these issues that we just don't know about yet.
That's great. Okay. Well, that's the end of our time, everyone. Appreciate all your interest in spending the hour with us. As I said, we will be creating a FAQ page on our website. We'll be trying to push that information out to you directly as well. And there is that dedicated page already where all the information for the past 2 weeks or so that we've been creating and writing about related to COVID-19 and how it impacts businesses, not just employees, not just loan programs, but your contractual rights, other things to consider around force majeure and other legal implications that this is having on businesses is all there. And so we welcome you, invite you to go there, reach out on our webpage. In the attorney bios, you have the ability to find our cell phones, obviously our emails. We're here for you to try to answer any questions we can and help guide you through this, knowing that we're all going to get out of it at some point and be stronger because of it. So once again, thanks again for your time, and hope to hear from all of you soon. And I want to again thank Matt, Steve, and Taylor for all the work you've done, not just in preparing for this webinar, but getting this information, distilling it down, and making it digestible for business owners. So thanks, everyone. Take care and stay healthy.